For starters, when a marriage is said to be void, it is bad and irredeemable. If a marriage is said to be voidable, it is bad but redeemable, only by the person whose legal right has been trumped in the process of contracting the marriage, not by just anybody or any third party to the marriage. A marriage is void when it is celebrated under the following conditions. When either of the persons involved in the marriage is lawfully married to another person. This means one of the parties involved in the union is either married to another person under the act or under customary rights as at the time of celebrating the marriage. This scenario automatically renders such a marriage bad and irredeemable and a legal nullity. When the persons involved in the marriage are within the prohibited degrees of consanguinity and affinity. A prohibited degree of consanguinity is when the parties are related by blood. For instance, a marriage of a brother to a sister, cousins, an uncle and his niece, an aunt and her nephew, and so on. Meanwhile, affinity relates to a relationship by marriage. For example, brother to sister-in-law, sister and brother of a couple getting married to each other. In a consanguineous relationship, an exception does not exist. That is, siblings are not allowed under any condition to be legally married to each other. However, on application to a judge of the state high court of the residence of the parties, individuals within the prohibited degree of affinity can be allowed to marry each other if the judge is satisfied that there exists a reasonable exception to permit the parties to marry one another. This exemption is covered in the Section 4.1 and Section 2 of the Matrimonial Causes Act. Another scenario is when the marriage is not valid under the law of the place it takes place due to lack of compliance with the laws of the region where the union is made. As pointed out earlier, marriage under the Act is regulated by a uniform body of laws in Nigeria, so uniformity must exist in line with spelled out regulations of marriage under the Act. Under customary marriage, on the other hand, each region has its own custom governing marriage in Nigeria. Therefore, the rules of each custom under which the parties are celebrating their union must be respected, failure of which the marriage becomes void. In addition, if a couple are celebrating their marriage in a licensed place of worship, either a church or a mosque, non-compliance with the rules of celebrating marriage in that place of worship renders the marriage void. Section 21 of the Marriage Act. When the consent of either of the parties to the marriage is not obtained, this happens if one of the parties is a child of unmarriageable age and consequently is incapable of giving consent, and of the parties was given or obtained under duress or coercion. One of the parties is under a mistake as to the given identity of the person to whom they have given consent to marry or the nature of the ceremony to be carried out. One of the parties is insane and incapable of giving genuine consent or understanding the contract of marriage. 3.1 and 2 of the Matrimonial Causes Act. When the marriage is unknowingly celebrated by either of the parties under the false name. When the marriage is celebrated without a marriage registrar's certificate of notice or licensable, or by a person not being a recognized minister of a licensed place of worship. For example, an Anglican priest conducting a marriage ceremony in a Catholic church, non-compliance with any provision of the law for the celebration of marriage. As stated earlier, voidable marriage is a bad marriage, but not beyond redemption. Such marriage can only be validated or redeemed by the person whose right has been affected by the marriage and not by anyone else. Now, the following circumstances make a marriage voidable at the instance of a party. Either of the parties to the marriage is incapable of sexually consummating the marriage. Either of the parties to the marriage is of unsound mind, mentally defective, and subject to recurrent attacks of insanity or epilepsy. Either party to the marriage is suffering from venereal diseases in a communicable form, or the wife is pregnant by another person other than the husband. And 5.1 A to D of the Matrimonial Causes Act. Any person who intentionally goes ahead to marry any person already married under the Act in Nigeria is liable on conviction to an imprisonment of 5 years. Previously explained, marriage under customary law refers to marriage in compliance with the various native cultures and customs of the various peoples of Nigeria. The underlisted are factors that can make such a marriage invalid. Marrying a person who, to the knowledge of their other party, is already married to another individual under the Act renders such customary marriage invalid according to Section 39 of the Marriage Act. Repayment of the bride price paid during the celebration of the marriage by the husband back to him works to invalidate the marriage. According to Section 3, subsection 2 of the Matrimonial Causes Act, any marriage conducted based on identity fraud makes the marriage voidable at the instance of the other party. Marrying a minor under the age of 18 without the consent of the parent or guardian renders such marriage invalid.